Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. Rudy Giuliani initially filed for bankruptcy after a federal jury found him liable for defaming two Georgia election workers and awarded them nearly $150 million in damages. Last month, at the request of Giuliani, a federal judge dismissed his bankruptcy case. Today, we'll break down what happened and what this means for Giuliani. I'm Adam Friedman, managing partner at Friedman Vartolo, and joining me today is Friedman Vartolo's senior associate, Richard Postiglione. Rich runs the bankruptcy department at Friedman Vartolo and has extensive experience navigating the most nuanced and complicated bankruptcy matters. Rich, how's it going today?
Hey, Adam, thanks for having me. I'm excited to be on my first Weekly Friedman.
Excited to have you here. So before we jump in, do you want to set the stage for us a little bit? Where was this bankruptcy filed? What chapter was it? What else should the audience be aware of before we dig all the way in?
Sure, Adam. This case took place right in our backyard in the Southern District of New York in the Manhattan Division, actually just 2 blocks from our Manhattan office. It's a Chapter 11 under case 23-12055 for those who want to look it up. And it's presided over by Judge Sean Lane.
Okay. So was it surprising that this case wasn't successful? Like, was it assumed it would end in a confirmed plan, or like, was it surprising that it ended this way?
Not surprising at all. It's an interesting case. Just a little bit of background. When a debtor, any chapter files for bankruptcy, the debtor is expected to file certain schedules at or near the time of filing. So this is done so that the creditors are aware of that debtor's financial situation. So their assets, their liabilities, their debts, their expenses. Giuliani, in this case, never filed that complete set of schedules, which isn't unusual. It does happen quite a bit. He did eventually file a request to have more time to file his schedules. However, he never did it. He never filed a complete set. The schedules that he did file show that he owns multi-million-dollar properties in New York and Florida. He had interest in several companies, Giuliani Partners, Giuliani Communications, and Giuliani and Company. So not a lot of creativity there in naming his companies. But clearly to me, the big takeaway was the amount of unsecured debt, which totaled over $150 million, of which $148 million is owed to Rudy Friedman and Landria Moss for the defamation case that you mentioned earlier. The court here refers to them as the Friedman plaintiffs throughout the case, so I will as well. The problem for Giuliani, though, is that he's still a defendant in several other lawsuits. So the amount of judgments against him is expected to go up, making this case really difficult to ever confirm.
And get into that a little bit. Why is it harder to confirm a case because there's so many debtors or creditors? Sorry. Why is it hard to confirm a case if there's so many different creditors?
Well, so many different creditors equals so much more debt for him to reorganize. In this case specifically, he actually never filed a proposed Chapter 11 plan of reorganization. So that right there, it's impossible to confirm a plan if you don't actually file one. So his delay in filing his schedules and his lack of transparency with respect to his financial situation really made it impossible for this case to be successful. Like you said, he's got a lot of creditors, and what wasn't transparent at all as to how he was going to repay those creditors.
Let's dig into that a little bit. Is it just because, look, you have a fixed amount of money, and the more creditors you have, the harder it is to make everybody happy? Or is it also kind of like a really hard math equation? Like you have maybe you have a bunch of money and a bunch of different people, and it's just very hard to make everyone happy and move the money around in a way that's fair to everybody?
Well, that can't happen. I mean, if you're fully transparent and you're showing exactly how much you're making and exactly how much you owe, if you really boil it down, it's not that difficult to divvy out the money. In this case, he has a lot of creditors, and he wasn't transparent at all as to how much he's actually making. So this case was really dead on arrival. Throughout the almost 7-month-long duration of this case, he failed to disclose a complete picture of his financial situation. He's required to file timely monthly operating reports, and this is really to show his financial transactions. He never filed timely reports, and they were never accurate.
Was it surprising that he asked for dismissal? Like, is that a rare thing to have happen, or are there plenty of times where someone filing bankruptcy may ask for dismissal?
It does happen. I wasn't surprised. There was really increasing pressure for him to disclose his financial situation. And there was a lot that he was hiding. It turned out he actually had a contract for an upcoming book, which he had failed to initially disclose. He was also promoting a brand of coffee, which the court didn't know about. This was discovered through the media. So there was a lot that he was kind of keeping to himself. So creditors were demanding full disclosure. You can infer that he was really either not willing or not able to provide his proper records. So pressure was really mounting on him to do so. There was even a court order to produce certain documents, and he just never produced them. And it looks like he folded when he eventually filed a letter consenting to dismissal.
Okay. Can you walk us through like how this functions procedurally? Like, did he need to ask for dismissal? Could he have just dismissed?
So look at section 1112B of the Bankruptcy Code. No, he can't dismiss the case without court approval. So that section of the code states that, once a party makes the request, there has to be a notice and a hearing, and then the court shall either dismiss the case or convert to Chapter 7, whatever's in the best interest of creditors, if there's cause to do so. So the first step was for the court to find cause to do one of these two things.
So what would have happened if the judge denied it and converted it to a 7? I realize this might be a complicated question, but what would have happened?
It would have caused extreme delay. They would have to have appointed a Chapter 7 trustee who was really starting from scratch and digging through the case. That would have taken months. And that would be unfair to the creditors in this case. So really, the court found that there was cause to actually dismiss. There's a few reasons for it. I can get into it. First, the judge had to determine what was in the best interest of creditors. Like I said, it was dismissal. And the judge basically just looked at Giuliani's prior history. He said, look, he's been evasive in this case up until now. He will continue to do so. So he relied on Giuliani's lack of transparency. He concluded this behavior wasn't going to change, and it would be very costly to continue to try to chase him down for his records and then hire professionals to kind of analyze and make sense of those records. Okay. And like I said earlier, he's the subject of several lawsuits. So there's this unknown factor of how much he's actually going to owe to these other creditors, which leaves the creditors in this case in limbo, which isn't fair to them. So the judge decided it's in their best interest to dismiss.
Okay. So what happens now? Like there's no bankruptcy, right? People still are owed money. What's going to happen now?
Well, technically, the bankruptcy is still active. The judge did grant dismissal. He directed the parties to stipulate to certain terms for the dismissal. Surprise, surprise, they haven't been able to do so yet, mainly because those Friedman plaintiffs want him to pay their administrative expenses that they incurred in this case. He hasn't agreed to do that yet. I expect the judge will apply a little bit more pressure to get this the stipulation entered. At that point, creditors will be free to pursue their rights against Giuliani.
Okay. Rich, this was great. We got to do this again. This was really helpful.
Yeah, thanks for having me, Adam.
Definitely. So look, thanks for joining Richard Postiglione and I on the Weekly Friedman, your source for the most essential information in the default industry. If you have any other bankruptcy cases you'd like us to break down in the future, please let us know. We look forward to seeing you next time.